All right, now on to the reason why we're part right now of this presentation is to talk about what happens when USCIS denies a petition or an application. As I said earlier, my name is Carolina Rodriguez-Neufeld. I'm the Managing Attorney of Clients Houston office, and I'll be joined today by my colleagues, Lauren Leal and Tatiana Hernandez. And we welcome you and thank you for being here today. We can go on to the next slide, please. Thank you. So first, I want to start by going over what we're going to be covering today and what we hope that you take away from this presentation. By the end of this presentation, my goal is that you will be able to identify different types of USCIS denials, the difference between a denial and a rejection, and to know the different options to responding to denials, as well as having a general framework to strategically figure out your next steps. Now, what we're not going to cover today, because this could be a topic that could take days to cover, is we're not going to cover the mechanics of how to craft an appeal or the wording to include in your motion to reopen or a reconsideration. That would have to be its own separate training. But today, we just really want you to know what to do when you get that denial and that initial shock has passed, and now you really need to start putting all of that into action. So we'll start by setting the stage. So you received your denial, stamped, denied, shock, fear, whatever, all the feels that you get when you've been working so hard in your client's case, and then you get your denial. I know it can be a lot. So I really want to start by first, what is the first thing that you think about when you get a denial? I'm going to actually include a word cloud here in the chat. If you guys can click on there and just put the first thing that comes to mind when you get a denial. Please keep it PG. I know that a lot of feelings come up when we get denials or a denial, but if you can maybe share the first thing that comes to mind when you see that denial in the mail. So we are going to put a word cloud. Sorry, I'm looking at the other screen really quick while we put the word cloud on. Thank you, Lauren. So if you guys can just go on to that. There we go. All right, so we'll start seeing some words. Oh, okay. Immediately just barred. Oh my, okay. Ooh. Rage. I'm gonna read some of these. Failure, disappointment, angry client, wrong. Okay, yeah, no, breathe. Yes, that's always good. Please breathe, especially after denial and you have a moment, These are, oh man, a lot of feeling. I get it. We've all been, so this is nice to know that we're not, all alone in these feelings. Oh, here in the chat, somebody put a disappointment and wonder what we omitted. Absolutely. We definitely start asking ourselves, where did things go wrong? What did we do, right? Great. So really, I think that the big answer here, so usually sometimes the initial feel that we get when we get these is, what do we do now? What do we do? I have this denial in front of me. I have to explain this to my client. So you really need to figure out what is the next step. All right, I'm going to go on to the next slide, please. And we'll talk about, so what do we do now that we have denial in front of us? So the reality is that there's not a one size fits all response. It's really a choose your own adventure kind of moment. And in typical lawyer fashion, the answer really is that it depends what we do next. I know, as lawyers, we hate giving that answer. Somebody asks us, well, now what? And we're like, well, it depends, but that really is the answer in this case. So first, I really want to talk about some of the questions that you need to ask yourself when you get a notice to help you decide on the next best step. There's different legal requirements and logistical considerations that you have to keep in mind. And like so much of immigration law, there isn't always one right thing to do. Sometimes the answer will be to appeal. Sometimes it might be to not appeal, right? And each individual client's situation will present different options. So with the little book bag here, you might feel like you're in the house of danger, or you might be feeling super confident that you were right, and therefore you're feeling great about the next step. So we're here to help you get from that initial state of shock, fear, frustration, and turn that into actions to help your client. We can go to the next slide, please. All right, so the first step is that we're going to demystify the process, and we're going to go through the initial steps after that, that first shock of getting the denial or a rejection. And we're going to break this down into a 4-step process to help your client succeed in obtaining legal relief. So we're going to start with our first step, which is what type of denial? And this is really probably the most critical question to ask because it's going to determine the options that you have. Now, there are different types of denials. And I would love if folks can get on the chat here, and if you can share what types of denial are you thinking about, like which ones have you seen in your practice? And I know we've all gotten denial, so this is a total judgment-free zone. So please feel free to share the kind of denials that maybe you've seen in your own practice or maybe in your colleagues' practice. Okay, we have a denial on the marriage, EADs, adjustment of status denial. Yep. No. Great. Well, thank you guys for sharing. RFVs, U visa applications filed by previous counsel. Yep. Great. Okay, so while we're looking at the different types of denials that folks are adding here on the chat, one of the questions that I always like to ask is, how do we know if what we have received is actually a denial or if it's a rejection? Because that will have an effect on the way that we address this question. So we can go on to the next slide, please. Thank you. So what is the difference here? So a rejection means that USCIS has determined that the filing did not meet all of the minimum requirements, including a submission of the initial evidence or the criteria for acceptance was not met, be rejected for improper filing, whatnot. And we're going to talk about the different types of rejections, or the reasons for rejections, I should say, in the next slide. A denial is a USCIS actually adjudicating the benefit request and determining that the applicant or the petition for the benefit does not meet or has otherwise abandoned or has not shown that they are in fact eligible for the benefit. So rejection is not a determination on the merits of an application, while denial is a denial on the merit of the benefit or request. All right, and we're going to go on to our next slide to talk a little bit about what are some of the reasons for rejection. And we're going to actually put a link here in the chat. And I would love for folks to also kind of join in and maybe share some of the reasons for rejection that they have seen in their practice or have seen in other colleagues' practices. And I think, okay, the link is now live in the chat. And I'll give folks a few minutes to maybe share some of their rejection experiences. Now, rejection in regards to your immigration case, other kinds of rejection, that's for another time. So just share. And if you go to the sticky notes right there to the left, you can add their type of rejections that maybe you have seen in your practice. Oh, here's a great one. Personally, one of my favorites, the rejected I-589s for ridiculous empty boxes. Yeah, we've all been there. We have wrong form, out of date, outdated version, improper filing, incomplete form, missing signature. My personal favorite, which is USCIS human error. Pages from old form mixed with current. Oh yeah, that's missing pages that are not missing. I know we've all been there. Thank you guys for sharing. This is very, very helpful. So yes, I want to focus on some of the ones that we see the most often. And let's go on to the next slide here in a second. And we'll start with, like a second for it to go back. There we go. Incomplete request, and it happens to all, to the best of us. Sometimes we will actually send in our filing and we are missing some information, or we're missing some part of the application or petition that is absolutely necessary. We also have the no fee, improper fee, or the fee waiver denial. I know that a lot of us have sometimes, submitted a waiver and it comes back denied for no reason. Or sometimes I know that this happened to me. I've been, sent an application with the fee and it's been rejected for lack of fee, which again, that might bring us to human error, or sometimes it's just the wrong fee. Then we have an old edition of the form. As you all know, USCIS tends to update these forms, sometimes with very little notice. So it is not hard to sometimes just send out the wrong outdated form. We also have no visa, oh, sorry, I missed one. No signature or improper signatures. I know I've gotten sometimes rejections because the signature was not legible. Sometimes that can happen, or sometimes you do miss a signature on the form. Some forms do require multiple signatures and they can get a little bit confusing, especially when you have the interpreter signature, the preparer, the client, whatnot. No visa immediately available. I know that us who do work with SIJ, that can definitely happen. We're trying to do the adjustment of status if there is no visa that is actually available at that time. And principal application error, that can be in a situation, for example, where you have somebody petitioning for your grandchild that is not a qualifying family relationship. So that would definitely be rejected without USCIS even reviewing the merits of the case. And of course, like somebody actually said on the board earlier, we have the USCIS human error. We've all been there. They'll say that we're missing something and it's clearly part of the packet. I know folks see that a lot with the fees. They'll say that it's missing the fee, even though you have submitted the money order with it as well. All right. Now, the primary way to deal with a rejection is to refile. I know that's not super exciting, but that really is sometimes the easiest and the best way to just deal with this. And I think somebody mentioned that in the chat earlier, that what's nice about the rejection is that you can just refile when you do get a rejection. Now, refiling is not the only way to deal with a rejection, especially in cases where the rejection was so erroneous that you absolutely want to fight this, or times where the date and time of the rejection matters, or sometimes the refiling is not going to fix the issue because it will mean that you would have missed a deadline. So in that case, sometimes refiling won't really be an option, but in that case, we actually suggest reaching out to the ombudsman for help. Do keep in mind that the ombudsman will not be able to help with a decision on the merits. So if you didn't like the decision that was made, the ombudsman's office is not going to be able to help you with that, but they can help in cases of rejection where there was an erroneous reason for why they rejected your petition or your application. Also, is another thing that I always like to make sure for folks to keep in mind is that you cannot appeal a rejection by USCIS. This is expressed in both regulations and policy manuals. So this does limit the options that you have available when it comes to rejections, as opposed to dealing with a denial where you have a bit more options on how to address those. All right, we'll go on to our next slide. Yes, so what are some of the reasons for an outright denial? If folks want to put maybe some of those in the chat, I would love to hear some of the reasons why people have seen denials in their cases. Oh, I see here, denied I-765 for no pending I-589 when the I-589 is in fact pending. Criminal issues, yeah, that's always an unfortunate one. Any other reasons for denials that folks might exercise of discretion? Absolutely, yes, that is definitely, actually criminal issues kind of goes hand in hand with that, right? Because sometimes criminal issues could lead to like an outright denial because it's one of the requirements, so to not have certain criminal issues, but it can also be a matter of discretion that will reach your denial as well. And also, I do want to throw in here, I haven't seen it yet, but also USCIS error. Like, I mean, I know it's hard to believe, but USCIS does make mistakes, even when it comes not just to rejections, but also to denials as well. So I'm now going to hand it off to my colleague, Tatiana. She is going to start talking more about denials. And actually, I want to read this one really quick in the chat, that they did not believe a birth certificate was legit because it was issued years after the client was born, issued a NOID, but denied before the deadline for me to respond to the NOID. That is probably one of the most annoying things. I have had that happen a few times where you're like, you gave me till this date. Why not let me at least answer? Absolutely. Yes. Actually, thank you so much for mentioning that, because that has happened to a lot of folks where it gets denied before they even have a chance to respond to the NOID. And on SIJ, no DHS consent. Yes. Thank you for sharing. So yes, I will now pass it off to Tatiana, and she's going to tell us a bit more about denials.
Sorry, I have to mute myself. Okay, so yeah, we went through that step one of figuring out what type of denial. Now this is more towards our step two of figuring out why did USCIS deny the application. Some of the reasons that were mentioned are listed here also, but typically denials will fall into 4 categories or buckets, and that can be for either the applicant is ineligible, and I'm going to kind of unpack each of those a little bit, but ineligible, lack of legal basis, abandonment, discretionary, or mix-up, file loss, USCIS error. So after evaluating all the evidence submitted, including any responses to an RFE or a notice of intent to deny, RFE meaning request for evidence, the officer determines that the requester is ineligible for the benefit sought, the officer will deny the benefit request. Upon denial of the request, the officer updates all relevant electronic systems and issues a written decision informing the applicant for the reasons for denial. So for denials based on the lack of legal basis, this is generally when the benefit request does not have a legal basis for approval, and there's no possibility that any additional evidence could establish a legal basis for approval. So the officer could issue a denial without first issuing an RFE or NOID if they determine that there's no legal basis for the approval. This includes any filing in which the benefit sought or the legal basis for the benefit sought or submitting a request an inactive or terminated program. So, or things that are held up in litigation. So as we've seen at different times with DACA, family-based petitions at different times under different categories. An example of a family trying to apply under a different category that doesn't exist or has not existed is a grandchild with a grandparent. So those would be just lack of legal basis, and they could be straight out denied without RFE or issuing a NOID. Abandonment denials are when USCIS denies the benefit request because either the applicant failed to appear for an interview or comply with a biometrics appointment, failed to provide an original document, or other evidence when requested to do so. So when USCIS denies an application for abandonment, they have to notify the applicant and the authorized representative as appropriate of the decision in writing. This kind of denial is without prejudice, which is important. We're going to talk about how that impacts what your options are later, but it's without prejudice and a refiling, and you can refile the benefit request in this circumstance. But it is important to note that the priority or processing date of a withdrawn or abandoned benefit request can't be applied to a later benefit request. So in this circumstance, if an application is denied for abandonment and you reapply, you do not recapture that priority date or filing date from the previous application. So in terms of discretionary denials, this is where sort of those inconsistencies that were mentioned might come in, or sort of, I think someone mentioned in the chat, like criminal issues, this is going to fall into this category. And it's important to keep in mind when figuring out whether the denial is proper or appropriate in your case, what is the standard for the discretion being applied? Because the analysis for discretion in asylum versus an adjustment versus a waiver of admissibility is all very different, and you need to be aware of that in order to determine whether they appropriately applied the legal analysis in your case. And then the last one, mix up, file loss, USCIS error, USCIS mess up. As it was mentioned in the chat, we see that happen often where there might be an application pending and something is denied because there's no application pending, like an EAD, or they didn't get the timing right in terms of how many days it needed to be pending in order for an EAD to be submitted. So it's important to take that step of determining why they denied your application in order to take our next step, which we can change the slide, which is when was the denial issued. It's important to know in terms of what your options are, when did they make this decision? Sometimes decisions can be given if you're at an adjustment interview in person. Sometimes they can be issued electronically, or they can be issued by mail. Oftentimes there's a letter that's issued by mail, and on the date of the letter, it might be issued on one date and the envelope in which it was sent is a different date, and when you received it is a completely different date. So it's important to know all those dates and be aware of them in order to determine what are your filing deadlines. So the date of the decision is the date the decision was issued, and the service date is the date it was mailed, not the date it was received. So it's important, like I said, to keep that envelope or to pay attention to the date on the envelope because it might be inconsistent with what's on the actual letter. In terms of figuring out your deadlines, even though technically the regs state that a motion or appeal has to be filed within 30 days of the decision, if you can conclusively demonstrate that USCIS did not mail the decision until long after it was issued, so the date on that letter is way before the date on the envelope in which it was mailed, then you can extend that 30 days or get more time based on the date it was actually mailed. So the service states the date was mailed, not the date it was received. It's important to keep in mind. So like we said, in most cases, you're going to need to apply within 30 days of the date of service of that denial or adverse decision. And appeals and motions to reopen or to reconsider have really strict deadlines. So we're going to go and unpack those deadlines in a second, and what the differences are between appeal and a motion to reopen and motion to reconsider. But it's important to adhere to those deadlines, as you know, when in circumstances when it's required, and we're going to go through that in a second. It's important to keep in mind in terms of the filing date for an appeal, how quick you have a turnaround, because it is, when computing the time period, there, you start with the first date after the date the decision was issued, and not the first business day, but first calendar day in terms of computing those 30 days. If the decision was issued by mail, you have 3 additional days in which to respond. So that would be 30 days as opposed to 30 or 33 days as opposed to 30 days. And there's in big letters here, beware of fee waivers, because if your application gets rejected for the lack of fee or for an incorrectly filled out fee waiver, you can miss your appeal window. And that could push you back by that deadline. I mean, it doesn't mean all your options are foreclosed. I mean, there are things at that point that you can try to do in remedial measures, but it's better to be really sure that you're either going to get granted a fee waiver, or when possible, submit the fee so that you don't have to deal with the possibility of rejection. So we'll unpack that a little bit more later in terms of being careful with fee waivers, but just want to give that advisory. So then the next step, we've determined first what type of denial it was, why did they deny the application, when did they deny the application, and now our next step is to choose from your next course of action. What are you going to do in response to that denial? So we put in the handouts, and I think we're going to switch over and show now a chart. We're going to unpack each of these options as we go on, but just want to give you kind of an overview on this chart, this handout. It's the denial response chart for you to determine what options you have after receiving a USCIS denial. So you can see there, it's kind of cutting to the chase of what we're about to explain, but sort of the options you'll have, the timing, the deadlines, the legal authority for them with the standards that you need to meet within the regs. And that way you can choose what's applicable or the best strategic option in your case. So our first option on the top there that you saw, and that I think we're going to jump back into, is the option to write a letter. I think this is something that you want to be judicious about choosing to do, because you have those filing deadlines. So you may write a letter to a service officer and you may not get a response in time. So in time to meet those filing deadlines for the motion to reopen, motion to reconsider, or appeal. But in situations where USCIS has made an error, this is a good option, because if they didn't fully adjudicate the claim, or they rejected or they denied unnecessarily, because in some of the examples that were given, there was a pending application. So they should have approved the EAD, or the priority date was current. So they should have approved or should have accepted the 485. In those situations, you can try and write a letter to the service center issuing the decision and see if they will on their own reopen and issue a favorable decision. So in this section of the regs that talks about motions to reopen and reconsider, which is 8 CFR 103.5, in section A5, it talks about that a service officer on his or her own can reopen a decision in order to make a new decision that's favorable to the affected party. So this is what you would kind of be relying on in writing that letter. And what it does is it gives you an option to get around kind of doing that I-290B and dealing with the stress of whether you're going to get a filing fee or dealing with those deadlines. And as part of our materials, we also have submitted a sample letter that shows a circumstance in which a pro bono attorney received a denial of an EAD, and to get around that denial that was based on USCIS error, he wrote a letter indicating what the error was to try and get them to reopen and reissue a favorable decision without going through, the formal process of a 290B and waiting for the processing times and all the things that come with a 290B aside from just the fee. So you have those in your handouts, and you can look at that sample when considering whether to write a letter or not. Our next option that we're going to discuss is when to refile. I think somebody mentioned that in the chat, is sometimes refiling is better in terms of what the basis of the denial was. So that's also part of why it's important to know, why was it denied? Is it better to just refile? You might do this because it might be faster to reapply, and it might save more money for your client than it would be if they went through the appeals process. So there's no publication of the processing time on the 290B, but in some circumstances, especially for an EAD, it might be faster to just refile and cheaper, because the cost for the 290B is $675, and whether you're relying on a fee waiver or not, and it's stressful to figure out, should the client have to pay it so you can avoid those timing stresses, or should you just go ahead and refile? And so in those circumstances, it might make more sense for your case to refile. Another example is there's no filing fee for the I-360. So if the client's still within the eligibility window, meaning that they're still under 21 and they want to get their application filed, they're still under the jurisdiction of the court, they're still eligible, then you might make more sense to refile based on, but that's going to depend heavily on what was the reason the officer gave for denying the original application. You can do both of these options at the same time, send a letter and refile. But it's especially for an EAD, but again, who knows if you will receive an answer on the letter. So again, you just want to be aware of, in choosing these, what's the best option given the filing deadlines. So another option, last thing I want to say about refiling is it's a great option for things you cannot appeal. And we're going to talk about what you can appeal and what you can't later in this presentation. So motion to reopen and motion to reconsider are both filed on the form I-290B, which we keep making reference to. So we're going to talk about the different standards that would help you determine which one is best, but you're going to use this form. The only circumstance in which you wouldn't use the I-290B is when you're writing to the asylum office to have them reconsider referral to court. So the majority of our cases, obviously with UCs, it's going to be a referral to court. It's not going to be to the immigration court. It's not going to be a full out denial. So in that circumstance, you would have to write a letter. You wouldn't use an I-290B. It would be sort of writing a letter / brief to the asylum office to have them reconsider the referral to court. And again, the deadlines would be the same, 30 days from the issuance of the decision, but there's no formal form that you have to submit. You would just be submitting a letter / brief to the asylum office that did the interview. But any other benefit, I-290B. So in terms of deciding what are you asking USCIS to do in that 290B, whether you're asking them to reopen or motion or to reconsider is based on whether you have new facts to state with supporting documentary evidence, or you want to establish that their decision was issued incorrectly and they incorrectly applied law or policy. So motion to reopen, like I said, the standards there, you must show new facts and be supported by documentary evidence. 33 days from mailing, but can be excused if delay was reasonable and beyond his or her control. So let's say you get new evidence and it's past that 33-day deadline. If you show that new evidence was not reasonably available when they initially made the adjudication, and that you, within a reasonable amount of time, you submitted that newly available information that made them eligible, you can get outside that 33-day deadline. The fee applies, but it can be waived, and you must file a brief concurrently with the 290B when you're doing a motion to reopen. A motion to reconsider must establish that the agency's based its decision on an incorrect application of law or policy, and that the decision was incorrect based on the evidence in the record of proceedings at the time of the decision. So this has to be done 33 days from mailing with no exception. The fee applies and may be waived, and a brief must also be filed concurrently. Okay, and the next option would be, if you do not do a motion to reopen or a motion to reconsider, you want to move on to whether or not you can do an appeal. So an appeal would be on the same form 290B, but it would be done before the Administrative Appeals Office, which will review, it's appealing the decision of the USCIS officer, which is a big distinction between a motion to reopen and motion to reconsider. Those go directly to the officer and office that made the initial determination, whereas an appeal goes to the Administrative Appeal Board to review that officer, that service center's decision. So what's interesting about an appeal, though, is that it's almost kind of incorporating both options, because according to the Administrative Appeals Practice Manual, once the USCIS field office denied the immigration benefit, they will have to review the appeal once it's filed and determine whether they want to take a favorable action and grant the benefit request. So they can treat it as a motion to reopen or reconsider and approve the application, or they forward the appeal and it gets just reviewed by the Administrative Appeals Office. So it's an appeal to a different and then in terms of whether or not you can make an appeal, how do you know if you can appeal? Well, for starters, looking at the decision, the denial will show you. So the top clip is from a decision of a denial of an I-360, and the bottom is from a decision denying an I-192 waiver of inadmissibility. So it says there, if you do disagree with the decision, you may appeal to the Administrative Appeals Office. Waivers of inadmissibility are not appealable. So that says there, the decision may not be appealed. However, for waiver of admissibility, you can file an I-290B to reopen or reconsider the decision that was issued. So the excerpts from those denial letters will tell you whether or not they can be appealed. So, but the AAO does not consider appeals in the following scenarios. Rejected applications and petitions. So when a field office rejects an immigration benefit, the request may not be appealed to the AAO. It doesn't retain a filing date, and there's no merits-based decision for the AAO to review. So that's why they do not petitions. Abandoned petitions or applications and petitions. The field office's denial of these abandoned or administratively terminated, administratively closed, they cannot be appealed to the AAO, but you can file in those circumstances a motion to reopen to the field office who issued the decision. Withdrawn applications and petitions, the AAO will not review, and denied motions to reopen or reconsider will not be reviewed by the AAO. So you can't appeal a field office's unfavorable decision on a motion to reopen or reconsider unless the field office original decision was appealable to the AAO. So in that same example of the two denials that we showed before, an I-360 decision was originally appealable to the AAO. So that's something that can be appealed to the AAO, versus the waiver of admissibility. If they deny the motion to reopen or reconsider, because the I-182 wasn't originally appealable to the AAO, it cannot be appealed at that time. And then the AAO does not receive appeals for unfavorable decisions from themselves, issued by themselves. So if the AAO gives an unfavorable decision, that cannot be appealed. But the appellant may file a motion to reopen or reconsider the AAO decision with the AAO. And I think we're going to move to our next slide, and I'm going to switch it over to Lauren, who's going to help you determine how you can file an appeal.
All right, so you decide if you can file an appeal, and if you can, how do you file it? Tatiana mentioned you use Form I-290B. You have to file it within 33 days of the decision that was served by mail. There are no exceptions to that, so you have to be sure you get it in on time. The appeal must specifically identify any erroneous conclusions of law or statements of fact in the unfavorable decision on the Form I-290B or in a written statement attached to the form. So different from the motion to reconsider, the brief can be submitted after the I-290B is filed. So you file your I-290B and then you have 30 days to file your brief, which is good because you get extra time. So the appellant in the appeal has the burden of proof to establish about eligibility for the requested relief. And so unlike other appeals, you can actually include new evidence for the AAO to consider. You know, if you can think of anything that might prove that your client meets eligibility, I would highly recommend including that and gathering and thinking about any other new evidence you can to prove that. So Tatiana mentioned the AAO is independent of the field offices. They do a complete de novo review of all issues of fact, law, policy, and discretion. But something to note is that when the AAO is reviewing the file, they can bring up an issue that they've never brought up before. So that means you can get your denial from USCIS, you can then get annoyed from USCIS, and the AAO can come up with an issue completely different from the reason for denial and the issue in the NOID. And so an example, so if you have a custody issue and it's never been brought up before, doesn't matter. The AAO is doing a complete de novo review. Right. So we talked through all those options, and we just want to note that there's always the option to doing all of the above. You are not limited to choosing only a motion to reopen or a motion to reconsider or an appeal. You can try all of these options if there are grounds for them, and the AAO will consider each one independently. They may grant both motions, they may grant one and deny the other, or they may deny both. And so something to note is that the AAO might treat an untimely appeal as a motion to reopen because that is something that can be filed after the 33-day window. I also would like to note is that, you know, if you file a second petition for the same benefit while the appeal is pending before the AAO, USCIS will generally hold the second petition in abeyance until the appeal is decided. So those are just important things to note. But again, you can throw it all in there and just see what sticks. But I want to take the time to do a quick check-in in the chat. How many of you have filed an appeal and received a successful outcome? So if you want to do that, or I'm not sure if there's reactions, but I'm interested to know, you know, who's gone this route before, or if you haven't, say, you know, I'm new to this. Not a lot of answers, or maybe they're just not popping up on my end. Oh, thank you. So that's okay. That's why you're here. Oh, some people are saying I've done these. Yes, I-290B on denied I-485. I had success with an I-914A. Awesome, great. I'm glad to hear some of you have already had some success with this. And yeah, that's the point. When we have, you know, all these options, hopefully one of those options results in a favorable outcome. What if all else fails? Then we have, you know, the option of federal litigation. So federal district courts have jurisdiction by federal statute to review agency action. And so these agency actions, which is, you know, USCIS's decision or the AAO's decision, these are reviewable by federal district courts. So the action has to be final. You cannot have an I-290B as an appeal pending and also file in federal court and ask them to review the decision done by USCIS. But you will want to note that a final agency action is all you need. So you do not have to file an I-290B appeal. Administrative exhaustion is not necessary in this situation. And so there are a variety of reasons a federal court can hold unlawful or set aside agency action and findings and conclusions. And there are 6 standards, and I'm going to go through those with you. One that is commonly used is that the decision or agency action was arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with the law. So examples of that, it's not following policies or not in accordance with the regulations. If there was a pattern of adjudication in a certain way and there was no comment or notice, there's this expectation that based on prior actions that USCIS is going to act in this way, and then they don't, that's an indication of arbitrary or capriciousness. And so I'll go through the other 6 standards quickly. So if it's contrary to constitutional right, power, privilege, or immunity, if it's in excess of statutory jurisdiction, authority, or limitations, or short of statutory right. Next, if it's without observance of procedures required by law. And then next, unsupported by substantial evidence in a case subject to or otherwise reviewed on the record of an agency hearing provided by statute or rule. And then lastly, if it's unwarranted by the facts to the extent that facts are subject to trial de novo by the reviewing court. And so there's lots of things you can ask the federal court to do. Most commonly, I would say mandamus, so mandating the agency to take some sort of action. APA review, it asks that the agency decision is set aside and require that they take some action and revisit, reopen, make the decision in accordance with the law and regulations. So something to note for federal litigation is that sometimes you can just write a letter and just telling them of your plan to potentially file federal litigation is enough to get the agency to change their action. And so Kind was actually able to mentor a pro bono team who successfully filed a federal action. And the result of that was once they filed and the matter was set and scheduled, the AUSA reached out to USCIS and we were notified that USCIS would be reviewing the case. Essentially, the client received an I-360 approval and that client now has a green card. But this strategy of sending a letter in advance of filing was something that the team talked about quite a bit. Every person that we reached out to gave this as an idea, and ultimately the client and the attorney made the decision to file, and it resulted in the outcome we wanted. But I would not sleep on just trying to send a letter. And I also just want to take a moment to really encourage collaboration and working with this robust network of legal service providers. We are all in this together. To do this federal litigation, we collaborated with Human Rights Initiative of North Texas. We, discussed what they had done in the past. They gave us samples. CILA is always an excellent resource. They have a training on their website called Challenging USCIS's Denial of a Petition for SIJS under the APA. And I can't even tell you how many times I watched that. And they also connected us with Mila, who was a great help in deciding where should we file and who's going to be parties and everything like that. So if you have a case that is basically at the end of the road and this is the last option, definitely do some digging and reach out to your legal service providers to get some technical assistance. And so what are some other options? So we mentioned ombudsman requests earlier. When might you make an ombudsman request? Carolina mentioned earlier in our presentation that if you've never received the decision, and that can sometimes impact your timing options for reconsideration and appeal, that's a good time to reach out to the ombudsman. We also have other examples when you would want to reach out. So cases where the beneficiary may age out of eligibility, if the application or petition that was filed was improperly rejected, if the application or petition has where the client is in removal proceedings, and there's also this pending application with USCIS that impacts removal proceedings, that is a good time to reach out. Typographical errors in documents, lost files, file transfer problems. Something to note again about the ombudsman is you do need to take steps to remedy this with the agency beforehand. Carolina mentioned that earlier. You will need to prove that you actually made those steps. And so these other options listed, so demand letter that we just talked about, it can end up resulting in USCIS taking another look in lieu of filing a full-blown federal petition, congressional representative intervention. So almost every one of your congressional reps has a USCIS liaison who can intervene on behalf of the client. So that may be worth trying out. EOIR, there are certain benefits that USCIS might deny, and if the person is then NTA, the IJ can consider adjustment. The immigration judge might be more willing to exercise jurisdiction favorably, in some circumstances. This is highly dependent on your jurisdiction, on your judge, and on your client. So please make note of that. All right, so what impacts how you choose which option to take from your toolkit? And so this is really a non-exhaustive list of considerations. There's no way to really write out everything that you should be considering, but of course, timing is at the very top here. So are you within your 33 days of the decision? Is it faster? We've already talked about that, to just refile. Does that make sense here? So speed and deadline are really at the top of your considerations. And then below that is cost. Can you afford the filing fee? Do you want to take the risk of the fee waiver? What are the options? Is it going to be cheaper just to refile again? Client choice should always be at the center. Like I said earlier, my pro bono and the client decided, they wanted to file the federal petition instead of sending a letter. So client is definitely at the center. And there's a lot of things to consider. Will it be re-traumatizing? Can they actually obtain new evidence? Does the client even want to press forward? What is the likelihood of success? And balance that with the toll that it will take on the client. If there is very clear error, or if there's borderline error, you want to really weigh that and decide what's the best course of action. Other relief. Is this the only form of relief? How strong is the application or petition? Things to consider. And then we've talked a lot about resources. So for federal litigation in particular, the attorney filing needs to have admission into the court that you're filing in. And then filing fees are also, do you have the fee to actually pay for it? Okay, so in sum, we talked about our 4 steps. What type of denial do we have? Why was it denied? When was it denied? Which of the available options should I take? Here they are listed. I'm going to briefly share our next steps document, which, next time you're in a situation where you get your denial, well, I think this would be a good option for you to pull out and start considering when you're working through this. So let me just pull that up really quickly. Here we are. Okay. So this is the document, and next time you get your denial, I think, I think a lot of people in our office are using this to look at what their next option is going to be. I'll go ahead and stop share and I'll go back to the PowerPoint. All right. Now we have a hypo, and we're going to have a poll. But I'll read through the hypo first. So Mina, age 20, submitted an I-360 seeking SIJS. After 200 days, USCIS issued a NOID and then denied the I-360 5 days after the NOID response due date. The attorney did not receive the NOID in the mail, but followed up because the case status changed online, showing that the case was denied. The USCIS call center representative emailed a copy of the denial letter dated April 27th, 2023. And so our first polling question is, can you appeal the SIJS denial? And so if you'll just take the time to answer that question. Yes, no, or I need more information. And then y'all can go ahead, I think you can go ahead and answer then the second question as well, which is, can you file a motion to reopen? And then I'll talk through both of those. All right. Thank you for answering those. And so the first question you want to ask yourself is an I-360 denial appealable in the first place? And so yes, it is. How many days does someone have to file an appeal? 33 days of the decision date if it was mailed. But what we don't know is when did they, when was the decision decided? When, if ever, was it mailed? And so we really need some clarity on the timeline of mailing. So in order to figure out whether we're in that 33-day time frame. So if the decision was actually on the April 27th date, you would have about 13 days to get your fee together, to get your appeal, your I-290B form ready. And so you also want to be considering whether that's actually feasible. Does it make sense to refile? And one of the issues with this particular hypothetical is that the client was 20 when she filed, and 200 days have gone by. So the I-360 needs to be filed by the time she turns 21. So you're going to want to look at, is that possible? And, is it faster to file? What are our options here? Maybe filing a letter makes sense as well. For the motion to reopen, the standard is new evidence. So is there new evidence? We really need new information for both of these questions, or we need more information to show whether we actually can file a motion to reopen, because you need new evidence. All right. All right, so that concludes our presentation. We're going to open it up for questions now. So if you have questions, feel free to ask in the chat.
I'll read out a question that was put into the chat earlier that we answered via chat, but somebody put the date on the denial remains the starting date. Have you argued using a date stamped USCIS envelope that you have longer than 33 days? So Andrea, our colleague, chatted in chat that she has done this, and the AAO practice manual specifies that the service of notices and decisions by mail is complete upon the date of mailing and not the date the appellant receives the notice or decision. I also cut and paste, and to draw your attention into the chat, to the section of the regs that talks about the effective service by mail. So it says at the end, service by mail is complete upon mailing. So when it makes references to service in that computation of 33 days, that's where the date of mailing, which is the date on the envelope, is applicable in order to help you make that argument to have the 33 days from the date on the envelope versus the date on the letter. if there's a discrepancy between the two.
Thank you for sharing that, Tatiana. And again, I just want to remind you all that our handouts could be really useful resources when you do get that denial. And of course, reaching out to your fellow legal service providers to try to get technical assistance when needed.